Discussions on Senator Amy Marcos's Committee on Foreign Relations hearing also focused on one question. Did the arrest of former President Duterte follow proper legal procedure? Let's discuss how the arrest went and whether it was above board. And joining us tonight is Attorney Ruben Carranza of the International Center for Transnational Justice. Good evening from Manila, Ruben. First question. Attorney Nicholas Kaufman has already indicated that he may bring this up, the legal counsel of the former president, before the ICC. Is it something that the ICC will consider, the manner of the arrest of the former president?
Kaufman can bring it up. Whether the pretrial chamber will consider that the most important question is a different matter altogether. I should say two things. There's a principle in international criminal law. The Latin phrase is mala captus, bene detentus. That means a bad arrest, but a good detention. And some courts have actually adopted that rule, that even if there is a challenge to the legality and validity of the arrest of a person, who then is brought to another court, that court might consider the detention of that person as still valid as long as that person is given a fair trial. So the ICC has not explicitly ruled on that question. There have been other cases in which persons were previously arrested and they questioned the manner of their arrest in a foreign country, but when they were brought to the ICC, that question was no longer important because the ICC was giving them a fair trial. So that happened, for instance, in the very first trial conducted by the ICC involving a Congolese warlord named Tomas Lubanga. His arrest was questionable. He was detained in a manner that was challenged in his country. But when he was brought to the ICC, that question was no longer seen as decisive, and he was tried and eventually convicted.
Well, earlier at the Senate Foreign Relations hearing, the matter of diffusion and red notice was brought up. Is that relevant?
To the ICC, no. The ICC issued warrants of arrest. The warrants were served, and the person subject of that warrant of arrest is in detention at the ICC. The ICC does not look into, and will probably not look into, the manner by which a foreign state, whether a party to the ICC treaty or not, carried out the arrest. Another example, one of the persons now already in detention at the ICC, a Ugandan child soldier, was arrested as an adult named Dominic Ongwen. He actually surrendered to the United States forces somewhere in Africa. The U.S. is not a party to the ICC, but the U.S. turned him over to the ICC in any case. And these questions were never really raised and did not have to be ruled upon. And so to the ICC, what's important is that the person that is the subject of its warrant is in custody. That person can challenge that, of course, but I'm not sure that the ICC will consider this challenge decisive.
So this is all political noise and irrelevant to the matter, the most important matter at hand, which is the case before the ICC.
Well, let me wear a slightly different hat here. I went after the Marcos family as a PCGG commissioner in the Philippines.
Yes, I remember.
If you can look at who are around the table in the Senate, these are children of Marcos cronies arguing with the Marcos. And these are the same elite families that have ruled the country for years and decades. And they're just fighting for power and the spoils of power, pretending that this is about justice and accountability, because not even the Marcos cabinet members are talking really about justice and accountability. They wanted to have Duterte arrested because the Duterte family is competing with them for power. The Marcos family is apparently divided over that question, but I think it's also hedging. And this is just all opportunism. No one in that room was really speaking for the families of those killed in the drug war.
Well, the Justice Secretary Remulla threw it back to the Senate. Why don't you look into the cases of extrajudicial killings?
They have, the Marcos Jr. has been president since 2022. Why didn't he, in fact, look into it? And they did invoke RA 9851, which Marcos as a senator signed. That law allows for prosecuting and investigating crimes against humanity in Philippine courts. He knows that. I hope so, because he signed it. They could have done it. Any of these people in that room could have gone to the family of an extrajudicial killing victim and helped them, talked to them. Marcos Jr., the Remullas, Jaime Marcos, Alan Cayetano, none of these people has ever spoken to or commiserated with the victims of extrajudicial killings. They could have filed cases, they could have supported investigations. They blocked them, they withdrew from the ICC, they supported the withdrawal, and many of these same people, in fact, signed the Senate's ratification of the ICC treaty in 2010.
Right, so these are all very important points, Attorney. So I'm starting to think classifying things into two strands. One is, of course, justice, the matter of justice. The other one is the matter of politics, right? And while the ICC itself does not care about our politics, here we're discussing, we have a Senate hearing. Senator Jaime Marcos, who's chairperson of the hearing, she also said, this might have to guide kung may dumating pa na iba pang warrant. So, what are the merits of discussing it here precisely for that reason, to guide the future warrants that could possibly come in? How important is all this discussion about the diffusion notice versus the red notice? What is the difference, RA 9851?
Well, it's important in the sense that perhaps they will realize that if they wanted to stave off a trial or an investigation even at the ICC, they could do it now. They could try. The problem is that it was also the Marcos Jr. administration that challenged the ICC's jurisdiction in 2023. That's why the case took a long time to move forward as it has now, because the Marcos administration went all the way to the appellate chamber of the ICC challenging its jurisdiction. Now, if they really wanted to argue that the Philippines should be allowed to prosecute these cases, then they could have done so. They can do it now. Nothing stops them from investigating many of the same people who are hiding out because they fear they will be next to be arrested. The problem with that is that it probably will be too late.
So just a quick follow-up, Pawi. If they, for example, someone here decides to actually file cases against the former president, because some are saying that could be an excuse to get him, or could be used as a reason to get him back here, to face the trials here first on Philippine soil.
That won't work because the ICC has already exercised jurisdiction. Now, that doesn't stop the Philippines as a state from pointing out to the ICC somewhere in the course of the proceedings against Rodrigo Duterte that there is something filed in a Philippine court. The problem is that procedure, literally and technically, is provided for, is covered by the ICC procedural rules, and it says that the time to do that, to seek a deferment, already happened. The Marcos administration, in fact, sought a deferment, but it did not do anything during the deferment. So now the ICC will proceed.
And Attorney, I just wanted to zoom in on that topic of the diffusion notice versus the red notice, because it was really one of the main points of contention during the Senate hearing earlier. Under the definition of a diffusion notice, it states that it does not legally obligate member states to act on it. Does that mean the Marcos administration could be held accountable for the serving of the arrest warrant on Mr. Duterte, considering that they had discretion not to enforce it?
Look, there's an agreement between the Interpol and the ICC to cooperate. And that cooperation agreement, that's not limited to any specific aspect of cooperation, including warrants of arrest, including serving warrants. I think that this argument is among people who want to argue, who are pretending to argue about a technical legal question, when what they're really arguing about is whether the Marcos Jr. wanted to get rid of Duterte or not. And I think they should just be honest with each other, because this is really totally irrelevant to the fact that Duterte is now in custody of the ICC. So the problem with this question is that it nothing stops the Philippines as a state from working with the ICC. Even if it has withdrawn, yes, even if it has withdrawn, nothing stops the Philippines from doing that. And like I said, that's why I mentioned the United States example earlier, surrendering a Ugandan suspect to the ICC. The US is not a party to the ICC, but in some cases, it cooperates with the ICC.
Attorney, I had asked this of other lawyers. If the administration is really serious into looking after the victims of the drug war, should it not set up an independent body, a commission to go after the other perpetrators who are still here on Philippine soil, the police, the other people?
I wrote about this 2017, and I said, the ICC process will deal only with the persons most responsible
Right.
For crimes against humanity. And so in this case, the president of the Philippines, for example, there will be many other people and many other victims whose cases will not be part of the ICC proceedings. And I suggested that the Philippines, the government perhaps, set up a truth commission to discuss exactly how and why the drug war happened, and whether it was motivated by a sense that the drug crisis was real, or was it just some person's way of creating othering other people, to identify people who he claimed were doing crimes to win an election, for example. The other thing that the Philippines can do is something that the Philippines already did before. There's a reparations law for victims of the Marcos dictatorship. Over 10,000 people were given reparations because they were victims of human rights violations under Marcos. Now, will Marcos Jr. propose a reparations law for victims of the drug war? Maybe, or maybe not. But that doesn't stop other political leaders from doing so. So many other things can be done to provide justice, accountability, and reparations for victims of the drug war, and not just prosecuting Rodrigo Duterte or even higher PNP officials.
Right, because in this debate, it seems that they are only a footnote. At
Right.
least here in the Philippines, it's more the analysis of whether it was legal or not, etc., etc.
And in other countries, this was also done. Mexico, the ICC, the first ICC prosecutor was asked to investigate the drug war in Mexico. He declined. We don't have time to discuss why, but the president of Mexico before the current one, in fact, created a truth commission to investigate disappearances that happened in connection with the drug war. So there have been examples of other ways to offer truth and justice to victims of the drug war that understand that they are the persons who need these things the most.
All right. Well, we thank you so much for your time, and it was good to see you once again, Attorney Ruben Carranza of the International Center for Transitional Justice.